you for joining us today. My name is Ian Scott, and I am the founder and managing partner at Scott Legal. And today we are going to talk about moving from a non-immigrant visa, so for example, an E2, a TN, an H-1B, an L-1, moving from one of those types of visas to permanent residency or a green card. So we are going to go through a number of different visa categories, but I think the first thing I want to point out is that for each of these visa categories that we go through, we do have separate webinars that cover them in more detail. So we will be spending a short amount of time going through each of the different options, but we do have, again, separate webinars that go through these in a lot of detail. For example, one of the options that we're going to go through is national interest waiver, and that is a separate webinar in itself that is 45 minutes to 1 hour. So you can attend one of those webinars to get more detail on that particular topic. So we do hold webinars regularly. We hold a couple of webinars every week, and you can sign up for these webinars. And we will send you a link where you're able to sign up for these webinars. We will also send you some information where you can sign up for guides. In addition to webinars, we do have guides that talk about each of these different visa topics. So we will send those a link where you can sign up for these guides. And then this webinar is being recorded. So we will also send a link where you can view the recording. And the recording is going to be on our YouTube channel. And we regularly post videos that are webinars, but also we post videos that are on a number of different immigration and business topics. So we do encourage that you subscribe to the YouTube channel so that you get updates. If you do have any questions as we go through the presentation, please feel free to add the questions to either the Q&A box or to the question box. We will get to all questions. So let's jump right into it. So before we talk about the specifics, I do want to go over generally how the green card system works in the United States, because it is a bit different from the way that permanent residency system works in many countries. So in the United States, they do not have a points-based system. We see this in a lot of different countries where the country has a system where someone may obtain points for how long they've been in the country, whether they speak the language, their education level, their job experience, a number of other factors. And then once they reach a certain number of points, they are awarded permanent residency. And as I said, often one of those factors is how long they've legally been in the particular country. The United States doesn't have a system like that, unfortunately. And the system that the United States has is a system where there are a number of green card categories, and if you're eligible for them, you can apply. And the primary categories are broken up into family-based green cards and employment-based green cards. Under family-based green cards, we see a situation where we have green card categories further subdivided into immediate relative and preference-based categories. And we're going to talk about those in a bit more detail when we get to the next slide. And then under employment-based categories, we have EB1 through EB5, and we're going to touch on each of these employment-based categories except for EB4, which is a religious-based green card, which we don't handle that particular type of green card. But we will touch on each of the other categories, EB1, EB2, EB3, and EB5. So perfect. Okay, so let's talk about family-based green cards first. So the immediate relatives in the context of immigration is a defined term, right? So it's not what you would think of as immediate relative, which, people would consider their brother or their sister an immediate relative, but this is defined. So it's going to be U.S. citizen child over 21 that's sponsoring their parents, or a U.S. citizen that is marrying someone. So those are the immediate relative categories. And when you look at the immediate relative categories, the reason that they're important is because the green card is always available. Because one of the things with the U.S. is that in addition to what I described, where there are certain categories, and if you're eligible, you can apply. In addition to that, the U.S. system will only allow a certain number of green cards per category, and that's further broken down by country. But these restrictions don't apply to immediate relatives, so you can have an unlimited number of people getting green cards under the immediate relative categories. But unfortunately, that's not the same with the preference-based categories. The preference-based categories are also defined, so they're F1 through F4. And so there might be a category F4, which, for example, deals with US citizen siblings sponsoring someone. But every single one of those categories is delayed. So, and some of them are delayed quite extensively. So the category that I just mentioned, the US citizen sibling sponsoring their brother or sister, is delayed by about 15 years. So you wouldn't be able to get the green card because what's happened is that they've used up the visas that were available. People went on waiting lists, and the time for the people to get the green card is quite delayed. And most of these categories, all of them are delayed. All of the categories are delayed. Even green card holder sponsoring spouse is delayed, and they are quite extensively delayed. And unfortunately, the delays seem to be getting worse and worse. So those backlogs are present. It's something you have to deal with because you're not afforded any immigration benefit during the pendency of these backlogs. So in terms of processing, the process for green cards is always going to be the same, whether or not it's an employment-based green card or a family-based green card. The same in that either it's going to be a two-step process or a three-step process. Now, if the person's in the United States, then the person might be able to adjust status. And if they are adjusting status, and what that means is filing an I-485 application. If they're adjusting status and the category is current, so immediate relative, or the category is current under the preference-based categories, then they can file a travel authorization and work authorization and remain in the United States until the application has been adjudicated. If they're outside of the United States, they have to go through a consular processing program. And the three-step process, so the two steps would be filing the I-130 is the first step. So that's going to be the objective, looking at whether or not, for example, let's say you're marrying a US citizen, the objective looking at whether it was a bona fide marriage. If it was a child sponsoring their parent, objective looking at the birth certificate to make sure that there was a familial relationship. And then the second part of the process is either going to be I-485 or consular processing. Now, the third part of the process, in some instances, there's a third part. So under the immediate relative category, for example, US citizen marrying someone, they have to, after 2 years, they get a conditional green card. And then after 2 years, they have to show again that the marriage was legitimate. And so sometimes that can be a third step in the process. And if that particular example I gave, it would be filing an I-751 petition. Now, in terms of moving to a green card, this is a category, the family-based category happens all the time. So someone might be on an E2 or a TN, and they meet a US citizen, and the US citizen sponsors them. It could be that the person has underlying visa status for some time, and then they're in a preference-based category, and the preference-based category becomes current, and then they move to a green card. So this definitely is a mechanism where people move to a green card often, and we do see this. We see this quite a bit among many of the green card categories. The next way to move to a green card is through something called extraordinary ability. So the EB-1A is a green card category, and this is one that we typically see people moving to from an O1 visa. So an O1 is the non-immigrant version of the EB-1A, where the criteria are very similar to the EB-1A criteria, especially the O1A, or it's very similar to the EB-1A because O1 is broken up into O1A or O1B. And so what you have to do here is there a list of criteria, and you have to meet at least 3 of them. So the criteria are listed on the slide here. And if you meet 3 of them, then you move to round 2 of the analysis. And the round 2 of the analysis is really looking at, well, has this person risen to the top of their field? And and that's a fairly subjective analysis. So you could meet 3 of the criteria, and then once the government looks and at the more subjective aspect, the second part of the test, to see if you've risen to the top of your field and that your accomplishments or achievements rise to the level of granting you the green card. Until that happens, you wouldn't be awarded the green card. But again, this is a category that is often looked at after an O1 visa, and it is a very high bar. So the EB-1A extraordinary ability is a very high bar, and again, showing that you have risen to the very top of your field. The next category that we're going to talk about is EB2. And the first one we're going to talk about is EB2 National Interest Waiver. Now, EB2 is broken up into two different subsets. First is National Interest Waiver, and the second is just regular EB2, where a company is sponsoring you for a green card. So regardless of whether you're doing EB2 National Interest Waiver or EB2 company sponsoring you for a green card, there are threshold considerations. So in order to be even able to apply under the EB2 category, you have to either have an advanced degree, which is a master's degree or higher, so master's degree or PhD, or a bachelor's degree plus 5 years of progressive work experience. And all of these are or. If you already have the master's degree, you don't have to move to step 2 of bachelor's plus 5 years, or exceptional ability. And there are a list of exceptional ability criteria, and they're not the same as the extraordinary ability criteria that are listed above, but it's the list of exceptional ability criteria. And with the exceptional ability criteria, you have to meet 3 of the 7 criteria that are listed there in order to move to the next step of NIW. And now the threshold considerations, often people get confused and think that if they meet the threshold considerations that they're eligible for EB2 National Interest Waiver, but that's not the case. The threshold considerations are just regular EB2 considerations. So you would have to, in that case, look at the whether or not, once you've met those, then you have to look at whether or not you actually meet the more difficult part of the actual merits requirement of EB2 National Interest Waiver. And this is based on a case. The case is called Danisar. And what you're trying to prove is that the proposed endeavor, because you're always going to start out with the proposed endeavor, that proposed endeavor has substantial merit and is of national importance. This could be job creation, it could be economic benefit, it could be that you've invented something, and really what you're looking at here is that you're looking at, is there some problem that the US government sees as important, and that you're like, what is it that you're doing that is actually solving that problem? Often we're going to see a lot of expert letters here. The expert letters can look at whether or not you are, the expert letters can look at whether or not you are, why something is of national importance. The expert letters could look at how it is that you're well positioned to advance the endeavor, which is the second criterion. And but definitely these petitions normally have 6 or so expert opinion letters. We could also look at information that the government publishes to see if something is in the national importance, or trade magazines, journals, et cetera, to make an assessment as to whether or not what it is that you have proposed is of national importance. Now, the second criterion has to do with being well positioned to advance the endeavor, and what the government is looking for there is they're looking at your education, your experience, but also your track record, to see that you have done all this before and you've done it successfully, and or that you are well along in the endeavor, so that it looks like you actually are going to be able to finalize or be able to succeed in the actual endeavor. And then the final criterion looks at whether or not the government should waive the labor certification, because the government has said that they do find that it is in the national interest to have a process that protects US jobs. And as a result of that, they've said that that's nationally important. So they're looking at, on balance, is what the person's coming to the US to do, is that going to be something that is in the national interest? Now, for both EB1A and National Interest Waiver EB2, you were able to self-petition, which means that you don't need an employer, so you can self-petition. And the process is always going to be a 2-step process for this, and it's going to be filing, and this is for both of them again, for filing the I-140 petition. And if you're in the United States and the category is current, and right now EB1A is current for most countries, EB2 is not current for any country. It's about 1.5 years for most countries, but much more for India, much longer wait for nationals from India and China. But if you are in the United States and the category is current, then you can file an I-485 petition. And if not, you're going to be doing consular processing. And here for EB1A and EB2, we see a lot of people move to these categories from as we said already, for EB1A from O1. For national interest, we see a wide range. So we see people moving from H1B. We see people moving often from E2 visas to EB2 national interest waivers. We also could see them moving even from an O1 or TN visa to national interest waiver. It really depends on whether or not they meet the actual criteria, and that's really going to be how you determine. A lot of the time, people will be eligible for both EB1A and EB2. And when that happens, then often if they have a stronger case, we'll pick the one that's stronger, of course. But if that happens, then the one that's going to be better is going to be EB1A, just because, let's say they're equal. The one that's going to be better is EB1A, because with the EB1A, the individual doesn't have a weight unless they're from China or India. So the next green card category, and this is a combination of EB2 and EB3, and we talked about EB2 as company sponsoring you for a green card. So this is not within the national interest waiver context, but just company sponsoring you for a green card, and then EB3. And what we're looking at here is a very, very common way people get sponsored, often when they're on TN visa or H1 visa, or sometimes even an O1 visa. They get sponsored for a green card under the EB2 or EB3 perm requirement. So what that is, company is sponsoring you. It's a 3-step process. First step of the process with the Department of Labor, where you're going to come up with the job description. You're going to submit that to the Department of Labor. They're going to come back and say, well, this is the wage that the job should be given. Then there's going to be a job that you're going to utilize that job description for a recruitment process. And it is quite an extensive process. It does take, often a year and a half, close to 2 years to get the approval from the Department of Labor. And then you'll be in the position where you're filing the I-140, and everything that we talked about with respect to the I-485 is the same. If it's current, then you can file it. And also, the thing to keep in mind with this and any visa categories is that usually family members, children under 21 and spouse can join in the green card process. The next category that we're going to talk about is EB5. So this, we often see people move from E2 to EB5, and sometimes we'll see people on other visa categories, H1B or TN. And the first thing about this category is that it is an investor-based category. So people are going to be investing either 800,000 or 1,050,000 in a new commercial enterprise. And now the thing though with this is that they're either going to be investing in a regional center, which is going to be a much more passive investment vehicle, where, let's say, a hotel wants to start develop something, and they want to attract 100 or so investors, and each of them are going to invest $800,000, and they're raising capital. And in that case, the investor really doesn't have to do much. It's going to be a much more passive form of investment. And then the other direct investment will be the investor is actually a individual that wants more control over their own destiny. So they have their own business. It can be a restaurant or any type of business that they've invested either the 800,000 or 1,050,000 in. And the new commercial enterprise doesn't have to be brand new. It's an enterprise that's been around since 1990. And the difference between the 800,000 and the 1,050,000 is that whether or not the company is in a targeted employment area. So that's an area that's either 1.5 times the national average unemployment rate, or an area that's defined as a rural area. Those are both TAs. And so if it's a TA, then it's going to be 800,000. And if not, it's going to be 1,050,000. And you do have to invest. So it's not kind of the ongoing amount that a business kind of can generate. The other kind of key thing with respect to EB5 is that you have to create 10 jobs, and they have to be full-time jobs. And these are going to be jobs that for U.S. citizens and green card holders. So we definitely recommend that you get E-Verify so that you're sure that they are actually green card holders or U.S. citizens. And the direct investment is always going to require direct jobs, so people are actually working for you. But if it's a regional center, you can get an economist to talk about the indirect employment that's created as a result of the endeavor. Often you need a detailed business plan because the jobs aren't created right when you apply. And the investment does have to be linked to the actual job creation. So that's something to keep in mind. The big challenge with respect to EB-5 is that the source of funds. So there is a requirement that you have to show that the money came from a legitimate source, and that is quite an extensive requirement. It's not for the faint of heart. It's treated much more like an audit. And the other thing with EB-5 is that it is an equity investment, so you can't kind of loan money to an enterprise and then say that that's your investment. It does have to be some type of equity, but there's no percentage amount like E2. As I said, many people come from this. They do E2, especially often for direct investment. They'll do E2, and it'll be the business that they had in the US on an E2, and then they will maybe invest a bit more or utilize what they'd invested to apply for EB-5. And that is fine. And E2, though, requires 50% at least ownership. But whereas EB-5, there's no specific number. You could even own 1% of the business, and that would be fine. This is going to be a three-step process where you file the I-526 petition. And then once you file the I-526 petition, you are going to file the I-485, and you can file the I-485 concurrently. If the I-485 can be filed concurrently if you, as long as the category is current, and it is current. It is going to be current in many, many instances, just because there's a carve out. So if you're investing in the $800,000 category, then it is often going to be current for all countries. So if you're in the United States, you can file the I-485. And the great thing about that is you can stay in the United States while that's pending. And if you're outside of the United States, you're going to be looking at doing consular processing. Then once you get the green card, and you've had the green card for 2 years, then you will apply for something to remove the conditions to show that you've actually created the 10 full-time jobs. So that's this one, again, it's a three-step process. And again, we have separate webinars on EB-5. So I do encourage you to attend one of those if you want more information. Some additional green card options that every year we seem to have someone who wins the diversity lottery. We might be working on an E2 for them or something like that, and they win the diversity lottery. So that's something that takes place in October. So keep your eyes open, and applying for that is a good idea. There are some humanitarian-based green cards where, helping police commit a crime, or it could be a U visa, victim of spousal abuse and things like that. So there are visas that are available for that. Other things to kind of keep in mind is that EB-5, if you do select EB-5 as an option, it is a long-dated option. So definitely one that you can get a green card, but it is something that is going to take 4 or 5 years just even for the I-526 to be approved. So while you're in the United States and you have underlying status, or if you file the I-485, you do have to kind of make sure that you're able to keep some underlying status that allows you to stay in the United States. So if you filed an I-485, if your category is current and you file that can be what allows you to stay in the United States. But definitely something to keep an eye on. And then also, if you don't, though, if let's say that you have some type of underlying status and you are not sure with respect to whether or not you're going to be able to file the I-485, and you have a visa with an underlying status that is like a TN or something like that, which is not a dual intent visa, you do have to make sure that you're able to renew the TN or similar visa. And that might be difficult if they know that you're trying to get a green card. And often we do see people doing parallel green card strategies. So that's something to keep in mind. And really, I think with this, planning is key. So those were all the prepared remarks that we had. And I believe I see some questions in the Q&A. So let's take a look at those. Okay, so the first question is, if an I-140 is approved, does approval remain ineffective for the child as well if the child turns 21? So it's a great question and a complicated one. So if the I-140, what ends up happening is that children age out when they turn 21, but not always, because it depends on exactly what's happening with the petition. Because let's say that the category isn't current, or there's a delay in the processing, then what happens is the age of the child stops. So there's a whole kind of complicated area called the Child Services Protection Act. So it is a complex calculation. So if you needed the calculation done, definitely contact an experienced immigration lawyer, because it is a complicated area. The next question, if the child has approved I-140 and the principal applicant is not eligible to submit the I-485 due to long queue of birth country, can the child submit the I-485 independently after turning 21 and not in the long queue of birth country? Well, I'm assuming that the child has the same birth, but I don't believe that they can. I don't believe that they can. One thing to keep in mind, though, is that your spouse, if your spouse has a different country of birth than you, because the queues are all going to depend on the country of birth. If your spouse has a different country of birth than you and it's shorter, you can use the spouse's country of birth, even though the spouse is not the primary applicant. I don't believe the child can apply though. And also I would have to check that, but I don't believe that the child can apply. But if you wanted a definitive answer, definitely feel free to set up a consultation with someone on the team and they can research that. But okay, the next question is, let's say if I have an E2 and invested 200,000 in a restaurant business, how can I invest more and what kind of other business to apply for EB5? So if you have a restaurant business that you started from scratch on an E2 and you invested 200,000, you should be able to use that 200,000 as part of the 800,000 if you're in a targeted employment area. And then you would just, whatever other money you invested, so even if you invested money and it was in cash and you were using that to pay for ongoing expenses in the business, then that could work. But what is not investment is money that is what's not investment is money that is the company just earns, right, and accumulates in the business. All of the investment has to come from outside of the company and invested into the company, and the money that's invested doesn't have to be towards the same line of business, but it does have to be within the same legal entity, right? So. Okay, so I think that is all the questions that we have answered. And yeah, so again, we're going to send out a lot of information to you, a link where you can set up a consult, the link where you can sign up for more webinars, a link where you can view this webinar on our YouTube channel and subscribe, and a link where you can get a number of different guides. So thank you, and I'll just do one last check for questions. Give me 1 second. Okay, so there's one more question here. I'm on an E2 visa. Can I work for a Canadian company and get paid in a Canadian bank account? Is that fine? So no, it's not fine. So if you're on an E2 visa, you can work for them if you're in Canada. If you're on an E2 visa and you're in the United States, you can only work for the E2 entity, even though you can't just work remotely for a Canadian company while on US soil. If you were working remotely for the Canadian company while in Canada, that would be no problem, but not from in the United States. Perfect. So again, thank you very much for joining, and we look forward to seeing you at future webinars. Thank you.